Hi, I want to engage with the topic courts. Is there a global rule of law theme that was set for the sixth volume of LP's Law Review, and speak about the challenges in administrative justice to ensure effective judicial protection. If we look at European trends in judicial review, we can see that there is a great process of Europeanization going on. We can see interactions between European law and international law, just to think about the Aarhus Convention, and of course between European law and national administrative procedural law and court procedural law, and of course also between constitutional law and international law, and in the other direction between administrative procedure and court procedure. So there are a lot of impacts coming to administrative procedure and court procedure, which all have the effect that national administrative court procedural law shows quite the same tendencies in a lot of European countries. And of course, this also has to do with the fact that there's more and more interaction between scholars and legislature, and too, as well as in European law. It means in Union law and European Convention law. And one of these signs is this recommendation of 2004, number 20, of the Committee of Ministers of the Council of Europe on judicial review of administrative acts, which we can say sums up or summarizes the crucial elements and the minimum criteria a national legal system has to produce in regard to judicial review. And of course, if we look on these criteria, we can see that these are very general criteria which all have several dimensions, and so it's just normal to say that we can see trends in administrative procedural law which all show us that there is a Europeanization going on. First of all, we can see that judicial protection gets wider and wider. Then we see a new balance in the separation of powers as administrative justice gets more and more powers. And of course, there's also this quest of timeliness, where we want to ensure that judicial protection is effective also in the dimension of time, so it comes in time. And these all show that there are a lot of challenges. The legislature and administrative case law is faced with how to ensure efficiency and effectiveness both of judicial protection and of public administration. So just some directions of this Europeanization, which all show, to my understanding, in the same direction. First, I entitled that we move from an enumerative model to a model with a general rule. That means that that as we move away in administrative law from the administrative act as an omnipresent and omnipotent figure, we discovered that there are also other types of administrative action, and of course judicial protection has to be opened up for these other types of administrative activity. For example, we can see that there are more and more countries where it's possible to proceed against failures to act, not only omissions to bring administrative acts, but also other types of administrative action, for example, service provision. Of course, this necessitates that there are different types of actions and procedures. So administrative procedural law gets more and more complex and differentiated, like civil procedure, and these codes of administrative court procedure also develop. Another direction of this widening is that there are less and less areas which are free from judicial control. Just think about the political doctrine question, which has a more and more narrow field. Of course, there's much judicial deference because administrative action needs, in a lot of cases, that margin of appreciation. But still, there is also control in this field to some extent. Another type of widening the scope of judicial protection is the widening of standing, whereby I mean that there's collective litigation possible in some fields of administrative action. So it's not only a subjective protection which is provided, but in more and more cases there's also possible that persons who do not have any personal interest that is harmed can bring cases before the court, and this gets somehow even typical. Let's think about climate litigation or environmental protection. Together with this widening of the scope of judicial protection, we can also experience a strengthening of the powers of administrative courts. For a long time now, we see the developments of interim relief, where we started with the only possibility to suspend the execution of administrative acts, and arrived at the possibility that the court makes obligations and prescribes what the administration has to do. And of course, there's another direction here too, that the courts get even the possibility to sanction the failure to respect judgments. Let's just think about the Turbarov case of the ECJ, where there was a Hungarian decision of the immigration authority which did not respect a previous judgment of the administrative tribunal brought in the case. And the ECJ stated that the court has in such cases the possibility to even amend the decision of the administrative organ. And of course, we can also see the strengthening of powers in other ways. And by this, we can also experience both the blurring of the frontiers of administrative justice and administration, as the changing role of procedural law. By latter, I mean that there are more and more procedural errors which can lead to the annulment of judgment of administrative decisions. And well, of course, there are a lot of dilemmas coming from this confluence of public administration and administrative justice, meaning that the frontiers are somehow blurred in some constellations. The first of these is the question whether courts should have reformatory powers, not only in cases, as mentioned, when the court is sanctioning the non-fulfillment of judgments of tribunals. So this question lies at the heart of the separation of powers, and we can see that we have to open up these questions again. Where is the border? Can the court amend administrative decisions, not just in order to have timely decisions, but also to keep up the rule of law? So it's a very interesting and engaging discussion that has to be led on this question. Another question is, as I already mentioned, the value of procedural law. We see that good administration, the right to good administration, leads to a bigger value of procedural law. And of course, a lot of you might know the Gemeindeantrieb and others versus Landrhein-Westphal's decision of the ECJ, where the Court of Justice loosened somehow the requirements of the causality requirement. So it said that even errors of the procedure which do not have an effect on the outcome of the case can be so serious that a decision has to be smashed by the administrative court. And this question was also revisited in the Commission versus Germany case. And of course, we can also see this dialogue or this question being raised in national law, like, for example, in France in the Danton et Eötvös case. And another question or dilemma is how it's possible to have parallelly administrative procedures and administrative court procedures, or in another way, can the administration remedy errors of its own procedure when the procedure of the court is already going on? And we can see that there are a lot of national laws which provide this possibility for the administration because of timeliness and because it's a often better way to remedy errors than to have the decision smashed and a new procedure conducted. But of course, there are also, again, dilemmas regarding the separation of powers. And we can also see that there are some constitutional courts which are not happy with this solution, like the Belgian Constitutional Court annulled this administrative loop. Finally, we also can see some tendencies of Europeanization in the organization of administrative justice. Of course, we are aware of the fact that there are different historical types of administrative justice, and of course, there are countries who adhere to the monist model and have no administrative courts or administrative justice separately from ordinary courts. Then we have the dualist model, where there are separate administrative courts or tribunals, either as a separate judicial branch or originally created within public administration as separate bodies. Let's just think about the French system with the Conseil d'État, which adheres to the administrative power. And there are also countries with a mixed model where these two models come in a mixture. But this is the historical the typology, and we can see that there's an organizational or organisatorial diversity developing. Of course, maybe we could say most European countries follow the German archetype from some distance. So we have countries which have administrative tribunals and courts on 3 levels, sometimes even with parallel financial courts, and other countries where there are 2 levels of administrative justice, and this does not even depend often on the size of the country. And of course, we have other countries which follow the German type from a bigger distance and have a unified Supreme Court and only special courts, administrative courts on the first instance or on first and second instance. That depends also on the structure of justice in general. So, for example, in Estonia and Slovenia, we have 1 level of administrative courts on the first instance, but in Spain and Latvia, we have even 2 instances of administrative courts and then the unified Supreme Court. And of course, there are also other types or nations which have another type of administrative justice where there's only an administrative court on the highest level. This is the case in the Czech Republic and recently also in Slovakia. Besides this, we have a lot of organizational changes. On the one hand, we see the expansion with lower courts, which began in France shortly after the Second World War and continued, so that we have there also a 3-level administrative justice already. This was also followed by Greece, and most recently we've seen that Austria also developed a first instance on the level of the Länder, and also 2 first instance federal administrative courts below the federal Verwaltungsgerichtshof. And maybe all of you know that in Great Britain we have also experienced diversification. This also goes hand in hand often with the establishment of special courts, not only financial courts, but courts for social security cases or in general for social affairs. And another direction is the creation of special courts for economic cases like competition law or other types of commercial or law. And of course, asylum cases also are a great challenge for a lot of states. So we see, for example, in Sweden, there are separate asylum tribunals. And where there are no special courts created, there we can also see a differentiated repartition of competences, where the legislature tries to specialize between the levels and puts priority cases to the second or even the first and last instance. And this is the case for norm control procedures, electoral procedures, or cases of regulatory authorities, or of cases stemming from the ministries. And of course, in some cases, having a Council of State, there's also a reorganization taking place or has taken place because of the case law of the European Court of Human Rights. So this all shows some convergence with the German model. And because of these tendencies, we can set up a more differentiated typology